Welcome to our Legal Insights channel. Today, we're diving into an important decision by the National Company Law Appellate Tribunal, NCLAT, concerning the invocation of performance bank guarantees during a corporate insolvency resolution process. This case addresses the interplay between the Insolvency and Bankruptcy Code, IBC, and bank guarantees, with significant implications for creditors and corporate debtors alike. Let's break down the key aspects of this decision. In 2015, Indian Oil LNG Pvt, IOLPL, entered into a contract with Punj Lloyd Ltd, Respondent Number 1/Corporate Debtor, which required the corporate debtor to provide an unconditional and irrevocable performance bank guarantee from the State Bank of India. The contract stipulated a mechanical completion date of March 23, 2018. However, the actual completion was delayed, and by March 2019, the corporate debtor was facing insolvency proceedings under the Insolvency and Bankruptcy Code, IBC. On October 30, 2019, IOLPL sought to invoke the performance bank guarantee due to persistent breaches of the contract by the corporate debtor, including delays and unresolved issues with an LNG tank. However, the resolution professional, RP, filed an application to restrain the invocation, leading the adjudicating authority to stay the encashment of the guarantee under Section 14 of the IBC, which imposes a moratorium on creditor actions during insolvency proceedings. The NCLAT, in its decision dated July 26, 2021, clarified that the moratorium under Section 14 of the IBC does not apply to performance bank guarantees. The tribunal emphasized that such guarantees are not considered security interests under Section 3(31) of the IBC, and Section 14(3), amended in 2018, explicitly excludes guarantees from the moratorium. In the specific case at hand, the adjudicating authority had earlier restricted the invocation of the performance bank guarantee, citing potential irretrievable injury and special equity concerns, as the liquidation process was underway. However, the NCLAT found that the lower authority's decision was flawed because it did not adhere to the established legal principles regarding unconditional and irrevocable guarantees. The NCLAT concluded that the invocation of the performance bank guarantee should not have been restrained and that the lower authority had erred in allowing the RP's application. Consequently, the NCLAT set aside the restraining order and dismissed the RP's application, reinforcing that the right to invoke such guarantees remains unaffected by the insolvency moratorium. This decision reaffirms the principle that performance bank guarantees are not subject to the moratorium under Section 14 of the IBC, ensuring that creditors retain their rights to enforce these guarantees even during insolvency proceedings. It provides clarity on the enforceability of guarantees and highlights the limits of the moratorium's reach. For any query or assistance with regard to IBC-related matters, contact us at WhatsApp 972-010-8105. Thanks for watching.